All right, everybody. Thanks for joining us. This is the Creative Finance Collective. This is where we get together and talk about all things creative finance, real estate, and answer questions that you have. Right now, we've got Drew Lewis from Georgia and Elizabeth Best from Scottsdale with us, and we may
Drew
have some other
Lewis.
folks joining us. I'm sorry, Jenkins, Drew Jenkins. Sorry about that,
You're
Drew.
good. You're good.
Who do I know? I'm trying to think if I know somebody
Oh,
named Drew Lewis. I know somebody who, well, in any event. Drew Jenkins. There is no equal. Um, Drew, you were saying you're going to, Vegas for a conference. Tell me about that.
right. So it's called the Captivate 2023. There's a law firm apparently out of California. I don't know how to pronounce their last name. I'm sure I'll butcher it, but it's like Garachi or something like that. And they apparently work very closely with a lot of the hard money lenders and private money lenders. And so there's a conference going on Friday in Las Vegas. And a good friend of mine, Craig Lawrence, is going to be one of the panelists at the event. And so he has very graciously told me to come with him as moral support. And so tomorrow morning we'll be flying out to that event.
So is it all real estate related? Oh,
It is, it is. It's all the, I mean, you'll recognize some of the names, right? Like PHH Mortgage is going to be there, the
okay.
mortgage office. So a lot of the vendors for sort of the private money world, or I guess kind of the larger private money world. Kiavi is one of the sponsors of it. Easy Street's one of the sponsors of it, right? Rock Capital. So I mean, a lot of the names in sort of the big, private money space and hard money space, they're all going to be there at that event, and a lot of them are going to be speaking, and so is my friend Craig Lawrence.
So what's Craig speaking about?
So Craig is talking about sort of some of the kind of what we talk about here, sort of on the attorney side for our clients, but he's talking about the creative ways and sort of how the market is going and how the private lenders are having to adapt to the changing market conditions by adopting some new strategies. And there are some interesting things that they're working on these days. There's some new case law out of New York that has a lot of the private money guys excited.
Cool.
Not that it helps us too much for what we do, but for the larger players, it definitely is something that they're all beginning to take advantage of.
Interesting. So if you're just joining us, this is the Creative Finance Collective. We're talking about all things creative financing. We've got Drew Jenkins out of Georgia, Elizabeth Best in Scottsdale, and myself, Andy Fowler, also here in Scottsdale. So we're taking questions throughout the entire hour. So if you're watching and you have a creative finance, real estate transactional question, feel free to pop on. If you got multiple questions, we'll try to take them as they come. So don't hesitate to ask away while we exchange pleasantries and see what's going on. Um, the debates tonight. Have you been holding your breath for the debate, Drew? You just waiting to get off this to go watch it, or could you care less?
Well, considering that I live in Georgia, there has been a lot of news in Atlanta recently, right? With everything going on there.
Yeah.
I normally would engage in the debates, but to be honest, I'm a bit excited to see my old friend. I haven't seen Craig in a while, so
Oh,
it'll be
yeah, I'll
good to
bet.
catch up with him.
Yeah,
But I
Elizabeth,
was
you're
I was
you're
just pulling the. Go ahead.
no, go ahead, Drew.
I was going to say, I was just pulling sort of what they're talking about, right? Because we talk about creative finance for our people, and the kind of things that they're going to be talking about are obviously opportunities and distress, navigating debt fund structures, insights from pioneering leaders. I believe that's going to be Craig's panel. Beyond expectations, unveiling the success story of DSCR lending, right? Of course, that's debt service coverage ratio, which all of our investors should be, intimately acquainted with, especially as more of the hard money lenders are beginning to actually do DSCR loans where they're looking more at the cash flow than necessarily they are at the appraisals, right? So there's some loan structures that exist there outside of sort of the normal market, a sort of alternative financing on it. Not other people's money, a private capital conversation, and mastering the art of vendor selection. Because you could imagine, there are lots in these days, just like trying to get our business as lawyers, there's also lots of startups and vendors trying to get the business of these sort of private money debt funds.
So this sounds like it's pretty this conference is pretty heavy lender focused. Am I
I
am
think
I
that's
right?
all they're actually focused on. I mean, I think
That's it.
it's just for the Captivate where deals and capital meet. I mean, it's just all about that kind of stuff.
What's kind of interesting, I guess, we'll have to let you report back to us. I'll be really curious to find out. Well, one of the things, and it was one of the topics we wanted to talk about, but this being that we talk about creative finance a lot here, there's always, when we're talking about the lender, whether they're conventional, whether they're hard money or some other lender, there's always the question on the due on sale clause and how in a creative finance transaction, it undoubtedly violates in virtually almost every circumstance the due on sale clause. I wonder if, given the interest rate environment we're in and the popularity of creative finance, whether that is going to be a topic of conversation at this conference from the perspective of a lender. I don't know if any of the particular breakout sessions that you're looking at going to suggest that that's a topic, but I almost wonder if that might be something they address and whether we get clued in on how they see that going forward.
I
Have you
said
heard
I
one
am
way or the
happy to
other?
report back when we get back. Obviously, I've never been to one of these before either, so it should be a lot of fun. And I'll definitely sort of keep my ears open for what the lenders are doing, because I'm sure there are things that they're doing in their world that may not be a one-to-one for us, but there's going to be strategies that we're going to be able to take back to sort of our smaller players involved in this field, and help them as well to better probably mitigate the risk. That seems to be obviously the most important thing for lenders.
Yeah. If you're just joining us, this is the Creative Finance Collective. If you have any questions, make sure to post them. We'd be happy to take them. Drew, I thought you'd find this interesting. Elizabeth and I were talking. We got somebody else popping on here. Scott Horne, thanks for joining us. Can you hear us?
Well, I don't know. I can hear you fine.
Okay, good, good. Hey, so you came in. We've got Scott Horne from Texas now, Drew Jenkins from Georgia, Elizabeth from Scottsdale, and myself from Scottsdale. Drew was telling us about a kind of a lenders-based conference that he's going to in Las Vegas, and I was just talking with Elizabeth a little bit ago, and we just saw recently a lender call the loan due, basically pursue their rights under the due on sale clause recently on a transaction. And we hadn't seen that in a good bit. And I know we've talked a little bit about it on the show or on the collective quite a few times about that being a possibility, and it's rare, but I was going to let Elizabeth kind of explain what happened, and maybe there's not too much more to explain than just that, but you recently saw that, right, Elizabeth?
Yeah. So I'm curious, does she really talk?
I do.
Oh,
Sometimes. Yeah, so the client had gotten a letter, or the original owner got a letter being like, oh, we noticed you changed into an LLC, like you have to explain it or whatever. So the client who bought it came to us, and we basically undid the transaction where we put the house back in the original owner's name, and then at the same time we're doing a agreement for sale and another warranty deed that'll go back from the original owner to our client. That's going to get held at title, and then we'll notify, or they're going to notify the lender that the title is back in the original guy's name, and then in a couple weeks we'll record the agreement. So,
well, I'm going to ask you to repeat that, please.
Too fast.
Do it again. I'm taking a little notes here real quick. We'll compare notes.
Yeah, so they got a letter, and I believe the letter gave them about 30 days to respond. And
I'm curious, who was the lender,
Rocket Mortgage.
Okay.
Yeah, and we don't know what triggered it. I don't know why they were following this property necessarily, but
yeah, as best we can tell, I think we think this is just they just did some due diligence. There wasn't, and I do want to get into this, all the wrong things that a buyer under a creative finance transaction can do to inadvertently notify the lender. Some of the ones that we're aware of don't appear to be the case here. They just happen to find out, as far as we know. But
so Liz, I'm going to interrupt you a minute, Andy, but so they get this letter.
Yeah.
And they always put 30 days in there, by the way. That's never a hard and fast date, I have found. It's months and months and months and months. There'll be letter 2, letter 3, letter 4. But from there, walk me through your step by step and what you were just describing, please, ma'am.
So, in the letter, because our client was operating under an LLC, so the letter was asking about the LLC, and so what we ended up doing was we did a warranty deed from our client back to the original owner.
So LLC to seller.
LLC to seller to put it back in seller's name, and we recorded that. And then at the same time, we had the seller execute an agreement for sale and another warranty deed from seller back to the LLC. And then we had that warranty deed was delivered to the servicing agent. Sorry, I got it confused. The servicing agent, we notified the lender that the property is back in the original guy's name. We're going to hang out for a couple of weeks, and then we'll record the agreement for sale. And hopefully the lender won't come back.
So here in Texas, we call your agreement for sale as a contract for deed.
Yeah, you might have problems there with that, wouldn't you?
Well, in this case, because it's going back to a corporate entity, no.
Okay.
It's just if it goes to an individual, it is. So a different ballgame there, okay? You know, I'm just going to make this comment because this is where so many investors fail. And something to think about on your end, Elizabeth, as well. And that is, I tell all these investors that, look, if you're going to buy the property and it's your intent to lease it, if it's your intent to fix and flip it or to live in it, I like to suggest at that time considering putting it into some kind of a trust. It may be a land trust. I just don't call my documents a land trust. I call them the Smith Family Trust, whatever the seller's name is. I'm not here to tell a mortgage company what I'm doing or anything else. Let them figure it out. And there's actually we do a Subto from seller to the trust. If they're going to do this, they go out and they get new insurance in the name of the trust and the seller's name, set it up, and I'll send a copy of the trust to the mortgage company. I won't do it up front, but if they ask for it, we'll send it to them if they have an issue with it. And I let it sit. Now, a lot, and I know we've talked about land trust before and whatnot, and everybody has a little bit different view on when to use it, when not to use it. They all think it's anonymity, which I kind of go, yeah, whatever. Or it's, they think it's
Obviously, I'm not the only one.
That's that response to it.
It's some magic tool to get around due on sale or whatever it might be. And too many investors get too caught up in, all of this fancy corporate footwork that we talked about in the past, utilizing, a Texas land trust or an LLC that has a Nevada LLC, then Wyoming, whatever it might be. So all this, personally, I think they get sold these bag of goods out there and it's just whatever. So I put it into the trust, actually make sure the insurance is handled right, which is where most of these things go awry, is on the insurance not being done properly. And if it's going to be kept in one of those three mechanisms, I have found that is at least to date, it's been the better way of doing that, just keeping it inside of the trust. And of course, I then have the entity, the LLC, purchases the beneficial interest from the seller. Easy. Okay. So do I tell the mortgage company that there's been a conveyance of the beneficial interest? No. Are they going to find a way to research that or find it out? No. It's not going to be recorded of record. It's going to be held back. The land trust could be recorded if they wish to do it. I don't think there's necessarily a requirement to do that. Most important thing, of course, is to record the deed and the deed of trust, to and from the land trust appropriately. Now, On the flip side, if the investor is planning on doing a wraparound mortgage to a back-end buyer, I don't like using the land trust in the middle. It's an unnecessary step because the conveyance from the trust to the back-end buyer utilizing, a wrap mortgage, it's a violation of due on sale. And you've just inserted the trust in the middle of this for no reason at all. It doesn't solve the problem. But a lot of investors out there are buying these, and they're not wrapping them. I get it. They hold them for rental property, short-term rentals. Some live in the properties. I get it. Some actually do fix and flip if they get the right deal. I get all that. And everybody does things a little bit differently. But, as you look at all of this in a way of doing it, I have found that if they will think about that, that's good. Now, I try to subscribe to the KISS, system because I need to do that. I need to keep it simple, guys. I mean, I got too much going on in life. I need it straightforward, simple, whatever it might be. And can I tell you guys, I hate these things. It's 7:15 and still ringing.
Still ringing.
And it'll ring until like 8:30 or 9 o'clock tonight.
And it's even worse that they think they can text you.
Well, they do that too.
They do that too.
It's your 24/7 hour attorney. I'm sure you guys do the same thing.
Yeah.
But and you always want to help people. I get it. But anyway, I like to kind of up front before I close a deal. I like to ask the client, what it is they're doing, what's their goal, and give them a suggestion. Now, they don't have to do what we just talked about. They're up to that. And in your case, Elizabeth, they didn't do that. They just dumped it into the LLC and went on. I get that. And of course, when you do that, it's all Alan's fault typically along the way.
That's quite the welcome.
Oh, wait, he's here. No, back it up.
We're all a den of thieves together, right?
Yeah.
Anyway.
Yeah, well, I don't mean to interrupt you, Scott. If you're just joining us and you're watching the program, we're talking about creative financing. So feel free we're taking questions throughout the hour. So if you have a question, feel free to go with to hand that over to us, and we'd love to answer it if we can. Scott, sorry to interrupt you. I know you were finishing out due on sale.
Hey, Alan, we were just talking about where a due on sale clause got called, and the investor bought the property into an LLC, and for some reason, who knows, they got a due on sale letter, and it was just, how do you handle that? What do you do with it? Is there a better way to put it together and structure it? And my suggestion simply was, I like to ask the client, what their goals are, and if they're going to rent the property, if they're going to fix and flip it or live in it. I'm a fan of going ahead and putting it into a land trust at that time, where I'm going to call the trust the Smith Family Trust. I don't call it a land trust. I make it look like a family planning trust, although it's just a land trust. Yeah. And that seems to work for the most part. And if the lender asks for a copy of the trust, here it is. If they ask for a $50 fee or $100 fee to change the name over on their records, great, guys, pay it. Move on. It's easy. Mm-hmm. But if there's going to be a wraparound mortgage on the back end, then that's self-defeating, because the wrap can cause the due on sale just as well, right? But once all of that happens, the question becomes, Elizabeth, what do you do and how do you cure that? And for instance, in Arizona, you can do your agreement for sale, contract for deed. And so long as that's an investor, it's easy.
Yeah.
And in Texas, that's easy. Now, my problem with that, though, is this. I'm not sure how Arizona law works. And Drew, you're in Georgia or where? Okay. Or what the...
Yeah, I'm in Georgia.
Yeah, what the necessary rules are in Georgia. But, what concerns me about putting a property into an investor's name, potentially long-term in Texas, under a contract for deed, is liens can still attach to the property left and right on behalf of that seller who is already in financial straits. I want to get as far away from them as possible, as fast as possible, in that instance. Now, is Arizona that way? Can liens attach?
Yeah, liens, if you're still on, bare naked legal title to the property like you would be in a contract for deed, you potentially have that
Right.
issue.
Yeah. So I just look at that and I don't, for that reason, I try to teach and preach, stay away from that, at least here in the Texas marketplace.
So Georgia has an interesting quirk on that. We don't have what are called notices of contract. Of course, we see them filed all the time in memorandums and all this stuff. But we actually have a statute that creates something called a notice of settlement. And it's only good for 30 days. And you can only renew it for an additional 30-day period. So you're looking at 60 days. But it will actually set your priority for the purposes of liens. Obviously, things like taxes and materials, mechanics, miscellaneous notwithstanding. But for like a judgment creditor that comes along and files after your notice of settlement, so long as you actually close within that 30 or 60-day period, you'll have priority over them because your notice was filed first. So your closing date will actually relate back to the date that you filed your notice of settlement, which is an interesting
But
thing.
that's
But again,
if you
unlike
actually,
y'all's, it has a very limited period of time. Yeah.
yeah. And I don't think you're going to have that in Texas. And most of these investors, they want it their longer term than, 60 days, unfortunately. And so, I just don't trust sellers. I've seen too many things happen from a negative perspective out there all the time. And so I'm going to try to find any mechanism I can to get it out of that seller's name. And so that's option one. So, but no, Elizabeth, what I've done in the past, and it gets messy, to be honest with you, and I'm just going to make a comment, why did Rocket Mortgage call the loan due? Did they go out and research title? I don't think they did. I just can't see that ever happening. Yeah. And could it have been something messed up on the insurance policy that caused them to look at something? Maybe.
Mm-hmm.
Could somebody have called somebody along the way and screwed up? Maybe. Could payments have not been paid timely and too many things ongoing? Maybe. And it's usually something like that, I think, that kind of triggers them to look into it. But, I think once everything gets to them properly, payments are being paid properly, I think the great amount of the time, these lenders aren't going to worry about it for the most part.
Yeah.
It's only if there's something becomes problematic along the way, do they, pull that trigger for some reason. Because the last thing these banks want is to own these daggone properties.
Yeah.
Yeah, the other most recent example we had of a lender calling due, it was actually last week. Jeff Watson up in Ohio, who you guys know, was giving the example, and that was one where they did a subject to on a loan that was already had already been in default, so it was already in the bad basket of loans as far as the bank was concerned, and they figured that out. So that was already kind of a problem from the get-go. But I'm curious, and I think it might be worth going through for the listener. There are things that you can do during a transaction that inadvertently can inadvertently put the lender on notice of what's happening. Everybody knows, hey, don't pick up the phone and call them. Drew, Drew, when we talked about this a while back, you had given examples where you had disgruntled parties to the transaction letting the lender know, but which I thought was pretty
Yes.
interesting. But I wanted to kind of hear from everybody in your experience, whether it's just a clerical transactional mistake that you do with insurance. I know insurance can be a big part of this. What are the big screw ups transactionally that can inadvertently put the lender on notice? Or things that are a part of the nature of the transaction that if you're not careful can put them on notice.
Alan, we're giving you center stage, Bubba.
In terms of percentages, insurance is the absolute most common reason for a problem with the lender. And I only have two insurance agents that I will allow to be used in my closings. And if they don't use one of those two, they sign off on a big, scary release, waiver, and indemnification agreement. And usually when they get that document, they say, oh, okay, we'll use one of those two. And so we've had 5 occasions where lenders called it due. one outlier was a condominium regime went bankrupt, and that caused them to cause the legal description and change for the properties, and that caused them call it due. We had one, my favorite, one seller had a big old giant home equity loan and sold her property and took all of her paperwork into this small local bank and said, "Hey, I sold my property that had this home equity loan. Now I want to get another home equity loan on this other property I have." And so they called it due. One was an unknown, one was a disgruntled seller. And then one, what was the last one? I forget the last one. But on 4 out of the 5 of the occasions, what we did is what I call a cat and mouse game. We deeded it back to the borrower, showed the lender that deed, and deeded it right back to the buyer. And that worked on all 4 occasions that we did it. I'm not a fan of the trust. The reason is underwriters are looking through that trust and saying it's a passive trust, and they're wanting beneficiaries to sign off on the documents, and then we have to write a check when that trust sells it, and the trust doesn't have a bank account, and they yell at us and such. So I'm not really a fan of the trust. Also because the incredible infrequency of the problem, and then the trust being more commonly causing problems. But other than insurance and people intentionally trying to get the lender to foreclose, I don't think there's much that causes it.
So Alan, you've also seen disgruntled sellers do this. What was it? Were they just disgruntled over feeling slighted in the transaction? What do you even?
The issue is, and Scott was talking about it a 4 sessions ago. These inexperienced investors are not educating the sellers sufficiently, and so this guy got angry and he did what I call pull the pin and hug your enemy, and said, "I don't care if you get a foreclosure on my record. I'm gonna make you hurt." And so I think in all fairness to that seller, he did not understand the mechanics of it because it wasn't explained to him. And so he got very, very angry.
Yeah. Guys, the old adage that no good deed goes unpunished is always out there, as Alan is saying. These sellers all have short-term memories. And Alan's on point, right? These investors do a lousy job at walking them through because they're trying to get the deal done, trying to make a quick buck, whatever it might be along the way. And they don't really take the time to walk them through, the primary, issues that are legitimate along the way. And we all know you can't fix stupid, right? I mean, there are people who will blow themselves up just for the heck of it. And, 2 years later, 3 years later, 4 years later, they call up, "Why is my loan not paid off? Why is this? Why is that?" And all of a sudden they forget that you pulled them out of foreclosure the great majority of the time.
Mm-hmm.
And now we're back over here where maybe they got some things going on and they want their loan paid off for whatever reason it might be. And now it's all of a sudden the investor's fault because they didn't pay the loan off in 2, 3, 4, 5 years, whatever it might be. And so they go ballistic and they may threaten all these kind of things. And, hopefully you can navigate around that as you have to. Most people, I've yet to find anybody that wants to get foreclosed on. But there's the idiot factor out there we all deal with occasionally. And, okay, it is what it is. And Alan, I don't disagree with the trust scenarios you talked about because, if you're going to put something into a trust, the investor needs to get a bank account. They need to do this, they need to do that. And they don't want to go through all this stuff. I just give them some options, along the way when they're looking at putting it based upon what they're doing as to how they can navigate it. But maybe you got to go get a trust, just is what it is. Go get it. Or not a trust, but go get a bank account. But Elizabeth, I want to go back to your scenario a little bit, and y'all are going to laugh at me at this. But let's take your scenario, and and I'm still not a fan of doing that agreement of sale because I don't trust sellers who are already in financial straits. Mm-hmm. Because if they're, most of the things that we work on, most of the time, I think our sellers are behind in their payments, and usually substantially behind. not just a little bit. But yeah, we convey it back to the seller.
Mhm.
And I do agree with Alan, you could just convey it back. Maybe you delay that recordation under agreement for 30, 60, 90 days before you record it again, realizing there's always that gap period where something could be, recorded against the property.
Mhm.
And that's why I'm usually trying to avoid. And so when I have your scenario, yes, I need it back. And then I go ahead and have the seller typically at that time transfer it into a land trust, notify the lender, and I stop. Now, the hard part when you do that is if you're dealing with a homeowner, let's say that you don't have an investor, but let's say this was a owner occupant who bought the property on a wraparound mortgage from the investor. So seller to investor to homeowner,
Mhm.
it's called. So of course our seller has to cooperate and convey back to the seller. Hopefully we all have sufficient power of attorneys that will allow us to do some things. So we don't have to incorporate the seller per se back in the equation. But then I transfer it into a trust. But how do you get it back into the seller's or back in home buyer's name under the same terms and conditions as they had bought it with a wrap note? And so then I go from the trust back to an LLC with a simple assumption arrangement, back up to the trust with a wraparound mortgage that mirrors what the seller or the buyer had bought the house with, and then assign the trust to the buyer. And that is just complicated as hell, and as complicated as I'll get out to explain also. But in that scenario, I haven't found another way to get around it per se. I mean, yeah, I can go back, and then you have to release the wrap mortgage. Then you have to, transfer it back to the investor, who turns around and transfers it back to the buyer again. And my question becomes, when you do that, is are you creating the same, scenario over again? Will that lender, for some reason in the future, be more apt to look at that deal 6 months from now or a year from now? And I don't know that answer.
Yeah.
So I get that you can dump things that way one way or the other, but I'm trying to project, at least what I try to do is a little bit longer term, just because I don't trust the lenders out there. And I don't think, as we talk about this, guys, there's not really a right or a wrong way to do it.
Mhm.
There's never found what the best way is. Every deal is so different all the time. And just depends on what the situation is, who the client is, who the lender is. That's the first time I've heard about Rocket Mortgage, by the way. I've only dealt with due on sale, I think 9 or 10 times ever in 25 or 30 years. So as Alan said, it just doesn't happen a lot.
Yeah.
So that's why I try to keep these as simple as possible, and and just let it roll from there.
Did Rocket just call one due on sale, or do they indicate that they're going to start calling more often their loans?
We just had one client who the original seller had a mortgage with them, and they found out that they had transferred titles, so they called it due. So we
I do advise, if we see that someone's wrapping around a small credit union, we
Mhm.
advise them the risk is higher.
Mhm.
And sometimes there's even private money lenders or other kind of lenders, and we let them know, no, you need to ask on that occasion and get a qualified assumption going on.
Mhm.
But like Scott said, I've seen 5, he's seen 9. I guess I'm a spring chicken. I haven't seen as many.
Mhm.
And I do like the trust in terms of it seemingly complying with Horne-St. Germain Act. And it'd be great if the title insurance underwriters weren't messing with us, and if the investors were getting a real trust in place, not a passive trust. I like it; it's perfect. But until it starts becoming a problem, I'm not gonna pursue that. I'll just do the cat and mouse game.
And I
Yeah,
got a
we
question.
talked about.
You brought up your title underwriter. And I get it that there could be title insurance involved, but I see, although I would love to have more title insurance issued on my Subtos and these kind of things, I just don't see that happening a whole lot. Are you seeing a lot of that, Alan, on your end?
So none on the FHA and VA. Underwriters aren't insuring that.
Yeah.
I would say probably 70% are insured for us.
Really?
Otherwise, yeah.
I would say maybe 3% from my end.
Oh, really?
Oh, yeah. I mean, always do
I-
an abstract and a title search, but
Yeah.
I can't tell you what it is.
Yeah. And I guess the reasons ours might be high is because we're always doing the Subto acquisition and then the seller finance wrap disposition. I say always on the great majority of them. And so that end buyer is wanting that traditional title insurance. On the Subto acquisition side, no. I'll take back what I said. That's maybe 10%, maybe, but on the wrap transactions, then they're getting the title insurance.
And that's where they're coming up, your underwriter has some issues with the trust being the seller.
Yeah, they're asking for the beneficiaries of the trust to sign, since it's a passive trust, and then we're getting yelled at. Is emergency? Hurry.
I would really like to know their reasoning behind that, though.
I'm going to go on
I
pause
can
for a
tell
second.
you
I have a
some of
closing
their
occurring.
Sure, go ahead.
And I can tell you some of the reasoning behind it is I have found over the years that obviously, we know that it's not really a legal problem, right? Like there are certain issues that look like issues, but we know at the end of the day, our client, whoever it is, the buyer would prevail in a claim. But what I've been told is the problem is the premium is this. And for us to have to go to court to prove the claim true, right, for the buyer to prevail, costs far more than the claim. So I've had to explain to clients is legally, I don't see the problem here. The issue though is the risk of the loss high, and they, for insurance reasons, are declining it. A great example of this is we had a gentleman who had purchased a property through foreclosure. And several months later, he came back and said, "Hey, can I get title insurance on this?" And if everything is clean, the answer, at least out here, is yes, you can get title insurance on it. Obviously, when you buy, there's some yellow flags, but you can get it insured. In this case, the previous owner was a sovereign citizen, and you have to love those
Oh,
guys, right? And so began to sue everyone under the sun. And then, of course, lost. But that has not prevented this individual from continuing to file suit. And so, for an insurance purpose, no, we can't insure this. And so, a lot of it has to do with the risk of the suit, because the cost of defending the suit is greater than the premium. And so, it's just a business decision on there, and has nothing to do with the actual underlying legal side of it. It's just business. And so when it comes to the passive trust, I mean, same thing here. We have to get certificates of trust. If you can't provide a certificate of trust, you need to provide a copy of the underlying trust for review, and who has authority to sign, just like you do with entities, right? And the risk is, if you don't get the right signatures in place, then one of the beneficiaries could say, "Hey, you forgot about me," and all of a sudden you're staring at a claim. And again, how much was the premium again? And how much is it going to cost me to go to court and defend this? And it's just business. I mean, you don't like to say that, but that's what it is at the end of the day.
And you're saying for all wraps or FHA VA wraps?
No, I'm just saying in general, like when you're trying to figure out why an underwriter, you're looking at something like you're talking about with your passive trust, why are you bothering the beneficiaries, right? Is it's less of a question of what's going on here as it is the perceived risk of getting dragged into a lawsuit and then weighing the premium against the cost of defending the lawsuit.
So the insuring, if I've got an underwriter insuring my wraps and Subtos and such, and everything's going fine, the FHA and VA, the reason they don't insure those goes back to 1990, when FHA said don't wrap our mortgages, and if you do, we're going to blacklist you, your office, from closing government-backed loans. And so right when they said that, some poor fellow, I forget what state it was, fee office attorney, closed FHA wrap, and FHA rolled in and said, "You're blacklisted." And since 1990, not one person has been blacklisted for insuring FHA or closing FHA or VA wrap that I can find in research. So I don't see any additional risk in wrapping or insuring an FHA versus a non-FHA. But man, those underwriters stay away from it like everything.
Yep. They just don't want to touch it. And to them, it's just a risk factor. I understand that. In the law office side, I don't mind doing it.
Right.
You know, and you work from there. And, you know, guys, I don't know all the rules, although I'm learning the rules and regulations in Arizona as we do this more and more and more. I don't know squat about Georgia, but here in Texas, about 98% of these deals that we close are homesteads. And in Texas, there's only 3 kind of liens that can attach to a homestead legally. And so it makes things easy to research, which is why there's not a whole lot of, there's reasoning why not to get title insurance out there. It doesn't mean that things don't happen and don't pop up. And we all know that even though you get title insurance, doesn't mean you may not miss, they can't miss something. It happens, from an underwriter perspective. And you just navigate it the best way you can. And I know that every state's a little bit different, and what may or may not attach to a homestead. Now, when you get into the non-homestead property, that rental property, where it might be someone's trying to sell. Now, of course, anything can attach. It becomes a little bit more problematic, where I can see more of an interest to get insurance, more protection mechanism along the way.
Explain.
So whose was that?
That wasn't mine.
I thought you had a closing. You got a dog at your closing?
No, phone call came in from the closing.
Ah.
Dog is security during.
What kind of office dog?
Oh, wait, actually, but my dog's with me at the office every day also. He's our mascot. If you go to my website, you're just going to see a big old picture of him.
Really?
Absolutely.
Awesome, Andy.
Oh.
It's
I like
fun.
office dogs.
Yeah.
There is a ongoing request at our office as to why we don't have a firm dog, and
Yeah, we're working on it.
I'm apparently the bad guy, and now I'm looking even worse. So
I got a question for all you guys, just 1 minute, because this came up today. A phone call was, and I believe I know the answer, but would love to hear from y'all. So memorandums of contract. We all just love those things. What would you say is the statute of limitations for a memorandum of contract?
So
Anybody
I'm
want
going to
to
jump in.
add?
I'm going to jump in since I'm laughing. There could be an argument that there is no statute of limitations because it's not a statutorily created lien. But if I'm going to guess, maybe a 4 years since the 4-year contract statute. I don't know the answer.
So I said here in Georgia, we have the notice of settlement. So we know exactly how long they last, right? They last 30 days and then can be renewed for an 80-day period, and then they're done, right? I also see filed of record the memorandum of contracts. I also see the affidavits of equitable interest, the affidavits of earnest money paid directly to seller, right? And so I shot an email to all of my underwriters, right? BCC'd and, hit all of those and said, how long until they clear and fall off? And they're like, we can't give you hard and fast rules, right? We have to take it on a case by case basis, obviously, other than the notice of settlement, which is a statutorily created thing for us. But they refuse to commit. In my mind, the affidavit of equitable interest, where they're actually releasing earnest money to the seller, that seems to carry a bit more weight. And it's been my experience that the parties that file those are way more aggressive than some of the folks that just file your run-of-the-mill notice of contract, hit and run, right? 9 months later, the poor seller has never heard from this person, has no way to contact them, and you're just kind of stuck.
Well, Alan, I'm kind of in your camp, where it's not a lien on the property, but it's a quasi cloud, as we all know. And again, most underwriters want them removed. That's I'm waiting for some new statute to come out on that somewhere that will help us out a little bit. Now, I think it may run with the contract where you might have that 4-year, if there's a breach of contract for some reason, you've got 4 years to file suit for a breach of contract. So I can see how those kind of run concurrently a bit. This call today, the guy had filed his memo in 2019. So I'm going, okay, that's pretty close to full 4 years. And he's going, well, what do I do? They're trying to sell the house now. And it's like, maybe you should go file a lawsuit for breach of contract if you're still within the statute, and force their hand at that a little bit if that's really what you want to do, besides just sitting back and doing nothing. But I'm with you too, Drew. We don't know the answer.
Yeah, and I think
I've seen a few title companies insure around it and not worry about it. But now, so we're a little more lucky here in Texas. And I know that Alan will agree with me on this. We see so many memorandums that are filed where the investor files the memorandum and he has a 1/6 interest in the property, maybe. Because they only got one of 6 heirs to sign, or maybe he's got 1 of 4 heirs to sign, or whatever, which I think is an invalid lien on property. And so we're always proud of our Republic of Texas statutes that we have, which makes it criminal to file an improper lien on property or a fraudulent lien on property. And I just wonder if you could ever employ that going, if you only got a partial interest and you're filing a lien on the property for some reason, I wonder if you could actually use that as a tactic to get them to release that memorandum in some format. I don't know.
The answer is yes.
You done it?
Yep. We've done it twice. And
I like
it's
that.
a beautiful procedure, especially in the smaller counties. Once you tell them what this is, then they take a look at it and say, oh, okay. And you get your order. It's a pretty quick process. Did one, Dallas County took about 3 months to get it. So it's worked twice so far.
So I'm
Georgia,
just
I don't
curious,
think they could do that either, because here it's very, very clear that the heirs don't have any like actual right in the property of the deceased until it goes through probate, or if they've been deceased for more than 3 years. And, we can do the affidavits of heirship and things of that nature. But even then, they're not actually vested until there's some sort of conveyance document. And in our statute, I don't remember exactly what it is. The statute specifically says that the liens of the heirs does not attach to the property of the deceased. So we don't even have to bother looking at any of the heirs' issues because their interests are not going to attach to the deceased property.
What do y'all have after acquired interest doctrine?
Yes, we do, so long as it goes via limited warranty deed or warranty deed. Quit claims does not have after acquired interest. So that helps us fix some of our title issues when things get recorded out of order, which does happen. So long as there's a warranty involved, the after acquired title and all of that interest will flow correctly.
anyway, I kind of like that you did that, Alan. Just you're trying to figure out how can you wield that big stick, to get these yahoos just to release it. And they think they're going to play the game being cute, and demand money and various things and hold everybody hostage. And I think if you have the ability to hit them with a demand letter going, y'all need to be aware of if that's the situation, that you have filed this invalid, lien on the property. I think it might give you certainly an opportunity to get them to provide a release of the memo more quickly, especially than having to go to court to do it.
We've got one right now that we closed. We closed it Monday, and we only found out in a title update that back in September, the person who became the administrator in June actually signed a contract with a guy, and they filed the memorandum of contract, of course, signed by the now administrator, but previously just one of the people. And I reached out to the other closing attorney. I was like, hey, you need to release this. You didn't claim anything anyway. Right. And not only that, but the property was subject to a condemnation lis pendens. It's been demolished. There's a $30,000 lien against the land, and to cover the condemnation proceeds. And we actually had to get an order from the court authorizing the specific sale because our purchase price deviated so significantly from the tax assessor's value. But you could imagine vacant land is not worth near as much as one with a property, even if it's condemned. So I was like, you just need to, it doesn't really attach to our record, but we still would just like it released anyway because it shows up under the property search. But it's the same thing, even though she ultimately was the administrator. She ultimately was one of two heirs. Whatever she did has no bearing on the property itself.
Yeah.
I get it.
And so Scott, and in Arizona, you can't record a memorandum period unless you have the authorization of the property owner. So early on, when memorandums were first a real popular thing, and everybody was just recording memorandums of contracts willy-nilly, those without the authorization of the owner are wrongful liens. And Arizona does have a statutory and a rule of civil procedure mechanism to allow us to get special action relief pretty quick to remove those liens. The only hurdle you usually run into is, judges don't see them every day. So you need to kind of come in with your paperwork ready to educate, like a law professor, like here's everything we're going to do. Here's why you got to do it and why it's okay and why we can get quick emergency relief. Sometimes without notice, depending on the circumstances. But we have a procedure to do that. Outside of that, you guys have, sounds like a 4-year statute of limitations on written contracts. Here in Arizona, it's a 6-year statute of limitations. So if it's a memorandum of contract that's been authorized by the property owner, the seller, you might have a 6 years while that sits.
And of course, Alabama, as we saw last week, they recently passed a law that took effect right this month, where if you're going to file it, kind of like you have to get permission to do it. And I didn't read it too closely. I don't, generally deal with this in Alabama. Mine are just more general, regular closings. But they went against whoever that one company was that was just filing all those crazy like 4-year liens or whatever. They targeted that,
the one
and they
from
targeted
Florida, right?
Yeah, exactly. Yeah, they targeted that, and they also went after the wholesalers as well a bit, and shored them up. And like to your point, right? You have to do all these disclosures in your contract, and you have to file of record exactly what you're doing, right, with the permission of the seller. And again, you cannot encumber the property. And I forget the time period, but it's much shorter than normal, kind of like with Georgia's notice of settlement, right?
Andy, I'm going to tell you that Alan and I are in the same boat where we don't want to go to court and do litigation and get things removed if we don't have to. That is the worst damn thing in the world I have to do. I didn't want to think about it. I would love to see something here in Texas kind of like that, where we could have a statute where you can't file a memorandum on the property, or if you do, there's a substantial penalty where you could get these guys. It's like either remove it or you're getting whacked with X thousands of dollars in attorney's fees and whatnot. And of course, then they don't have any assets. But for instance, here in Texas, we have I don't know about y'all states, but it used to be a few years back, if we had a judgment lien on a homestead, okay, fine, we'd just insure around it and move on, unless it was a really big judgment lien. Then the underwriter would take a look at it a little bit more closely. And they came up with a statute because underwriters now want judgment liens removed. So we've got a 33-day process where we can do an affidavit of homestead and release a judgment lien just to remove it. And it's done and gone. And I wonder, it'd be great to have something like that with a memorandum. We can make that easy process and just take care of it and make it go away. One day we might be able to get that. I think since Alan's in Austin, he just go down there and lobby for those kind of things to find a way to make this business a little bit easier.
I'll support anyone who wants to do that.
Unfortunately though, in all of these cases, you're always dealing with a title company, and sometimes there's a difference between what's legal and what's lawful and what a title company will stomach. And we had, like you, for the longest time in homestead matters, it was pretty simple. if the dollar amount wasn't there, they basically were like, well, this is not a lien by operation of law. It doesn't fit. We're just gonna move past it. The Arizona legislature changed the statute. They did, and they changed it in such a way that a portion of it, portion of the homestead equity, if it reached a certain amount, was a lien on a property, and it raised some questions. But then the legislature increased the amount again. And then what happened is, of course, that was challenged in the courts, and right now it's on appeal. And the Court of Appeals, when trying to address the legality of the legislative change of the homestead law, they were challenging the increase in amount. Now you have, like, I can't remember, it's $400,000 in equities protected now in Arizona. Well, that went up on review in the Court of Appeals. There was initially, they sought an order staying the enforcement of the law pending the appeal. Okay. Eventually the court denied that and said, we're not going to stay the enforcement of this law. I had recently had an issue with a title company that refused to, this wasn't a subject to deal. There were regular sale, but the guy had a judgment, and but under the new law, he was protected up to that amount. The title company said, it's on appeal. It could change. I said, well, of course it could change, but the courts have not stayed enforcement of the law pending an appeal. This title company was so worried about it getting overturned. And for the longest time, we could not convince this title company that, look, this is the law as of today. We don't have to do anything else. You're okay moving forward. You know what finally got them to move is we told the guy, just go find another title company. So he picked up the phone and said, I'm going to go find another title company. And they said, okay, we'll do it. And I was like, that was it. I mean, how much of legal research could you have saved us if we just made that threat early on? But sometimes they're scared, but if it's going to cost them, maybe they'll do it. I don't know.
Well, money
Title companies
talks, baby.
I mean, not only that, but I mean, if this is going on and there's something you can do to save the file, I mean, you pick up the phone, you call your underwriter. And if the underwriter can't do it, obviously, he'll pull in, senior underwriter or generally state counsel. And then if state counsel can't do it, we'll go up to regional counsel. And if it's something that we really feel strongly about, such as some folks from Texas really, really, really wanted an endorsement on a commercial file that I kept getting told, you can't issue, you can't issue, you can't issue. So we went all the way up to like national level counsel, and they're like, yeah, you can issue it in Texas. And we realized that agents issue it in Georgia, but you're not allowed to issue it in Georgia. And so even though they provided me with law firms that had issued this endorsement, I just had to say they did it without authorization, because all the way up to national. But I mean, that whole process took what, 2 days, right? I mean, underwriters are there to answer our questions. I mean, they're always there to answer our questions, and they want to make the money just like everyone else, right? I'm assuming it's not like a crazy, ugly deal.
Yeah.
And, you can get your answers pretty quickly if you just ask. But if the
Yeah.
title company's not even willing to ask, then I mean, that's on them.
Well, guys, it's been about an hour, and I appreciate you all taking the time. We got a big presidential debate tonight, and I don't want to miss it and lose any more faith in this country, which I know I probably will if I watch it. But in any
I
event,
say, you sure you
I
want to watch
appreciate.
that?
Yeah, I know. Well, I always get excited for those things, and then I come away just, I feel worse than I started. Come on, guys. I'll do better
No,
than that.
I would take the leap here and go, okay, who do you really want to hear from, or what it might be, but I'm afraid to open that door, that Pandora's box,
Who do I want to hear from in this debate? I'd like to see how DeSantis does. There's a few of them that I like. It'll be interesting. I don't know. I've always, I don't know. I'd like to hear from DeSantis, see what he's got. He's second, and now it's time to not. He showed a lot of what he can do in the way he governs. It would be interesting to hear what he has to say. Beyond that, I know a lot of them. That Vivek, he's kind of a newcomer. It'd be interesting to see what he has to say. But a lot of the other players I've heard from, so I don't think there's going to be anything surprising. But We'll see.
No, but they sure
Christie
do give
normally
a
tends to be
lot of hype on
entertaining.
it, don't they? I know.
Yeah. Yeah, they give a
That's
lot
how
of
they
hype.
make their money, is to get people to watch it. So, I mean, that's the name of the game.
Got it.
Well, hey
Well,
guys.
ladies and gentlemen,
Yeah, thanks for being with us and looking forward to doing it again. You guys have a good night.
I'll be sure
Good
to
to see ya.
report in next week about the conference.
All right, yeah, tell us all about it. We'll see you guys next time.